establish paternity. But once that is established, then both of you have equal rights to your child. Now, some of you get disadvantaged because maybe you didn't know that that was your child for a while, and the mom has birthed the child, bonded with the child, developed a relationship with the child. And you notice in Troxel, they look at that. They look at, do you have a relationship with the child? So that's very important that nobody gives up having that relationship with the child. Now, there's a difference with some of the parents, including the moms, when the courts are causing you to lose that relationship, when they are not allowing you, when they've restricted you. I don't like to use the word allowing because then you start getting into, okay, they grant or they don't grant, which is incorrect. When you're restricted and you cannot see your child, you need to continually make sure the court is not using that as a new status quo. And they will keep trying to do that. And then they'll say, now your child needs to transition and adjust and they're uncomfortable. I know that it's happening to some of you. But you still argue that that's not a sufficient legal situation, that that's been artificially created. And you need to put that on the record if you want to preserve the ability to argue that later. Because they'll pull some over on you. And if they put certain trigger words into the record, like status quo, child doesn't have a relationship now, and there's no defining around it, which they don't care about. They only care that they're covering their butts and that they're putting what they call facts in the record. If you don't counter it and you go to appeals, they don't know the difference. They just see those key words. So now you've got a situation where we've talked about how you can inflame the trial court. Well, there's also trigger words for the appellate court. So when the appellate court sees those certain things, they may just say, this has been satisfied. Lower court acted within their authority. It's your job to get that stuff on the record. Now, they may threaten you. They may try to intimidate you so you don't get that stuff on the record because it makes it difficult on them, right? And it limits their power. But just like anything else that we've talked about in the past, people get threatened when they challenge power. You just have to be smart about it. You have to be prepared to pay some of those consequences. It may not be fair or just, but there's one just recently that was told their lawyer was threatened, if you keep bringing up the Constitution, I'm going to put you in jail for contempt of court. Turns out we found out that that was because in that particular hearing, bringing up the argument they were bringing up wasn't related to the hearing that they were having. And the court does have that power and authority in their courtroom every day, every hearing. So it's also important that you know what kind of hearing you're in, what's being allowed to be heard, and if the other side starts stating things that you were told wasn't being heard that day, you need to object. And even if they let them continue and they're not letting you, putting that objection properly on the record should help you be able to argue that if you need to take it to the next level. So you can't be afraid of those things. And if a judge is going to attack you, there are some instances you're not going to be able to prevent that. But if you do give in or you cower or you let them bully you, then you could lose some of those rights. And that may not seem just or fair, but that is part of the process. It is a contentious process, right? You're in a battlefield when you're in that courtroom. So again, just remind yourself, back to the lunch counters, they prepared themselves when they were doing the desegregation of the restaurant lunch counters, the Freedom Riders, they prepared themselves. They knew that they could get beat up. They knew that the people that owned the restaurants had more power. They knew that they had the police on their side, that they could call the police in, the police could come drag them out, arrest them, take away their freedom temporarily, all those things. They even knew they could get beat up and killed. You're facing similar situations, and what you're fighting for is important. You're fighting for your child's rights, your right to protect and raise that child. So it shouldn't be odd to you or feel like you can't stand up to them for a worthy cause, because it is very worthy. Like I said, this is the most important person in your life. So it's beyond me why the courts even want to challenge parents in these situations, and I'm actually surprised that this has gone on so long, where parents have actually accepted that they're going to be told what to do by these courts. I don't think there's anywhere else in life you would accept this.